Hello, this is Scott Horton. We are now live and have the webinar open for attendees to join in. So we will allow several minutes to do that. We will start as scheduled. Again, hello, as people are now joining this live webinar. You should see the cover slide for the presentation, NLRB 2020, on your screen. You should also have access to a chat window. If you have that and you can hear me, you're in good shape. We are expecting a large turnout for this webinar, which is exciting. That's why I did open up a few minutes earlier to give everyone a chance to get in, and we will get started as scheduled in just a few minutes. Thank you all for joining us. We'll get started soon. I'll go over all of the general information right when we get started. But again, if you have access to the chat window and you see the NLRB 2020 presentation cover slide, then you are all set and should be ready to get going in just a few minutes. Thank everyone for logging in. We're still expecting many more folks to do so, so we will give them a couple more minutes. We will get started on time or very close to on time. I try to keep these to about an hour. That's my hope for today. We will have question and answer at the end, and with that, I'm welcome to stay on until the questions end. I will go back over the details right as we officially get started, but there will be the slideshow that I'll use, and you should see as we go, and I will make that available to you later on. But for now, hopefully you can just get logged in and sit back and relax and get started in just a couple of minutes. Again, we are very excited about the large turnout that we're expecting. We probably had our largest number of signups for this webinar of any that we've had. So I probably will allow an extra minute or two, but we'll get started very close to on time and again, aim to spend about an hour subject to questions, which we are always happy to stay on and answer. Again, with a larger number of attendees, hopefully that will mean there will be some good questions. But again, we will get through the presentation for those of you who do need to get going at the end of an hour. I'm just going to pop back in again. For those of you who've already heard me a few times, I apologize, but people continually join. I just want to make sure they have a chance to make sure that they can hear me, confirm that they have the slide, the cover slide NLRB 2020 on their screen. Hopefully can also find access to the chat. That's where people will be able to ask questions, which we will typically answer at the end of the presentation. We are getting very close to the start time, but we're still having people log in regularly, so I'm going to probably give an extra minute or two before we officially get started. Welcome. As people continue to join, we'll get started in just a couple of minutes. Make sure we get most everyone in the room before we officially kick the presentation off. So we are just now coming up on our scheduled start time. We plan to go about an hour from now, but there are still people joining regularly, so I'm going to give another minute or two to let them in, and then we will begin the presentation. Right, just before I get started with the actual presentation, I just want to mention we are scheduled at 1 o'clock start time today, which is about where we are right now. I just wanted to give everyone the opportunity. You can always contact us if that time is generally not good for you. Obviously, we do the best we can to accommodate everyone. We used to hold these at noon and got a lot of response that was actually inconvenient for people who had other obligations around the 12 o'clock hour. So we're doing our best to be accommodating, and that goes for topics as well. If there are different things that you would like us to be presenting on, we try to do these webinars on a nearly monthly basis, although we take time off every couple months so that it's not completely repetitive, and we wait for some new material from time to time. Anyway, today's presentation, NLRB 2020, updates for all private sector employers, should be a good one. If you are joining us, then you probably are not working for a public government agency, a city, town, state government, or public authority, for example. If you are and are just interested in the topic, then that's great. But the contents of this presentation are really particularly relevant to private businesses. When I say private businesses, that would actually include publicly traded companies as well, but just not the government entities. My name is Scott Horton. I am founder and attorney with Horton Law PLLC, practice labor and employment law as I have for going on 15 years now. And I'm very excited about today's presentation for a couple of reasons. One, we have great turnout. Two, the topic is of interest to me. I'm sure everyone has their own personal favorite federal agency. In my case, that's the National Labor Relations Board, which doesn't necessarily mean I always agree with what the NLRB does, but since I was in law school, it was just interesting to me the way they operate, because it is essentially a quasi-judicial agency within the federal government, where they haven't historically done as much by rulemaking as they have by deciding individual cases. One thing that means is their directives and interpretations of the Federal National Labor Relations Act change from time to time based on who is on the board when a particular issue is decided. An actual case involving a specific company and its employees and unions that may be involved. Before we get started, I did want to also emphasize, as it says in the title, updates for all private sector employers. A lot of people understand the National Labor Relations Board, if they're familiar with it at all, to have a role in union issues in U.S. Workplaces. But as we're going to discuss at length, there are various ways in which the National Labor Relations Board and the law that it enforces affect employers even beyond whether or not they have unions and their interactions with the unions and their employees in unions. So even in employers that never have unions, never will have unions, still have to abide by certain requirements under this federal law administered by the NLRB. One last reason why I'm excited about this presentation is from the standpoint of employers. I actually am able to give some good news today, mostly all good news with a couple of caveats, where for honestly most of the time I've been practicing, these presentations have been bad news in the sense of imposing additional restrictions and parameters on what and how employers do regarding their employees. But this is largely a presentation going in the opposite direction, telling you how the National Labor Relations Board is now trying to make things better for employers. At least that's my view. Here is an actual outline overview of the topics we're going to discuss. We're going to talk about handbook policies. And again, it doesn't necessarily have to mean that it's in an employee handbook, but written policies, or even in some cases, arguably non-written policies and procedures and practices that companies have, and why the National Labor Relations Board has some impact on those and what is changing and what has changed. We're also going to talk about a couple very recent decisions from the National Labor Relations Board in December that again affect all private sector workplaces, or potentially do, regarding email and confidentiality, specifically confidentiality related to internal investigations. Then I want to go over the recent rule changes on the representation procedures. These are the rules that govern how a union would actually get voted in to represent employees in your workplace, which again, many companies would not want that to happen. Some companies have already had it happen, but it is interesting to me, again, if nothing else, as a spectator, the National Labor Relations Board, to realize that this is an agency that actually conducts federal elections at private workplaces where your employees may at some point be called upon to vote either to bring in a union or remove a union in what is essentially a federal election run by federal agents. So that's kind of something interesting. We're going to talk about those procedures. Some of you, it may not matter because all of your employees are already in unions, although the procedures actually pertain to situations where the employees try to vote the union out as well. That's the less common scenario and less the impetus for the rule changes. But others of you will have the possibility of employees organizing going forward, and these rules may be important to you. And then finally, I do want to touch on some issues that are pertinent if your company does currently have employees who are represented by a union. The latter topics will not take up the bulk of the presentation, but they're important, and I wanted to discuss them for general interest, and then we'll do the question and answer at the end. Also, at the end of the presentation, I will make available to you the slides from this presentation, so you can keep them for future reference. If you have questions, go ahead and ask them through the chat as we go, although usually I will wait until the end to answer them. We will aim to end at the hour mark, but I will continue to answer questions afterwards as long as they are coming in. I just caution you in asking questions. Don't ask anything so specific because it's not going to be confidential. Other people will see the questions and or hear the answers. So don't ask something that shouldn't be shared in that way. And in that sense, there's no attorney-client privilege in my answering of those questions. If you need me to answer it confidentially, then contact me after the webinar and we can discuss that. I have this picture of 5 individuals up here on the screen because, in fact, there are 5 seats on the National Labor Relations Board. By my estimation, 3 of these silhouettes are probably women. I don't know that there have ever been 3 women on the National Labor Relations Board at the same time. For better or worse, there certainly have been women on the National Labor Relations Board. That being said, there are currently no women. Of the 5 seats, only 3 are currently filled. 2 are vacant, with the most recent vacancy occurring in December when Lauren McFerrin had her 5-year term expire. The historical practice, although the law doesn't exactly require it, is that 3 members of the National Labor Relations Board are from one party and 2 are from the other party, where normally the 3 from the one party match the party of the president, although there is some lag because they are 5-year terms. So when a new president comes in, it can take some time until they shift that balance. Interesting in a couple of respects. One is that currently all 3 members on the board are Republican members. All were appointed by the current President Trump. There are 2 open seats that were most recently filled by Democrats. I will indicate a couple of reasons why that's interesting and relevant going forward. I just want to throw out the disclaimer now that while at times I might editorialize or make comments that relate to political party affiliation of the board members, it is not me trying to make a political statement. It's really just the factual matter of how the NLRB has been operating for some number of years now and how it can reasonably be expected to operate going forward. So with all that being said, let's get into some of the fun information I have for you today. First of all, I wanted to discuss policies. Again, this is going to be mostly written policies that may or may not be in your employee handbook or personnel manual. They could be ad hoc policies, but regardless, why does the National Labor Relations Board have anything to say about that? Well, the National Labor Relations Act, which is the law the NLRB administers, has something in it called Section 7. Section 7 of the National Labor Relations Act gives employees certain rights. This includes the right to self-organize, to form, join, or assist labor organizations, which all basically together means to have a union represent them, to do the next part, to bargain collectively through representatives of their own choosing. In other words, once a union is voted in, they will then become the entity that has the right to negotiate on behalf of the employees as a group regarding terms and conditions of employment. But then there's this other part of Section 7 that says employees have the right to engage in other concerted activities for the purpose of collective bargaining and other mutual aid or protection. They then also have the right to refrain from any and all of those activities. But that underlying portion of Section 7 is what has always been understood to give rights to employees even who are not represented by unions, if for no other reason than they need to have that right in order to try to work together to bring in a union in the first place, or likewise, conceivably to be able to work together to try to get a union that has been voted in removed. But this concerted activities, again, is not specifically limited to whether or not we're going to have a union in the workplace. It also addresses any situation where employees are working together to try to better the terms and conditions of their employment, or to have wages changed or safety conditions improved. And over time, there have been various different ways that that right has been expanded or contracted, and that is largely what we're going to talk about next. So in about 2010, some of the cases started coming in just before that. The NLRB started what I'm calling here an attack on social media policies. There was a kind of confluence of circumstances where the Obama appointed Democratic majority took over in the National Labor Relations Board in the late first part of the late part of the first decade of 2000, and then by 2010 they started hearing cases, and these board members consistently ruled during their terms in favor of more labor and employee friendly interpretations of the National Labor Relations Act. Around that same time, if you remember, social media really started to become more commonplace through Facebook and Twitter, and now of course various other platforms, Instagram, even TikTok and Snapchat in some circles. So there's untold number of social media platforms, many of which have become ubiquitous, and we wouldn't imagine life without them these days. But around 2010, especially for business purposes, people were very concerned about what this was all going to mean for society, what employees could and couldn't do, and how many problems it was going to create for companies. So lawyers like myself began trying to counsel companies on whether they should have policies and what these policies should say. We thought we were writing pretty reasonable policies, but the Obama appointees on the National Labor Relations Board seized on the new technology issues to kind of blatantly give themselves something to do, as well as promote a pro-labor agenda. And again, I don't necessarily mean that disparagingly. The Democratic Party has traditionally received a lot of support from labor unions and has been more labor friendly than the Republican Party. But that shift in politics and the shift in technology combined to have a lot more decisions on social media policies than labor lawyers had ever anticipated leading up to that point. These decisions were pretty startling in many ways, and we started to see a lot of limitations on requirements that employees, for example, be respectful in the workplace, even that they be honest, and that they maintain confidentiality. All these things that forever seemed like perfectly reasonable expectations to have of your employees. But the National Labor Relations Board started to say, well, if you require employees to be respectful, then that might curtail their right to, get rude or argumentative when they're trying to exercise their Section 7 right to improve working conditions, for example. It's too much to require employees at all times to be honest because they have the right to engage in let's call it puffery when arguing their concerns. Confidentiality, for example, again, seems reasonable. You shouldn't be able to disclose company secrets and expect to keep your job. But the National Labor Relations Board started very carefully critiquing confidentiality restrictions out of concern that you were going too far in preventing employees from discussing their working conditions and salaries and et cetera amongst themselves or potentially with union organizers, for example. So we saw a lot of policies now that were at risk of being found unlawful by the National Labor Relations Board. Is that a big problem? Well, maybe not. There typically no financial penalties involved with merely having a policy that the National Labor Relations Board would eventually find problematic. If you fire someone for violating one of these policies, that becomes a different issue. You may have to reinstate them or pay them back pay. But another way these policies started getting challenged was in the context of union organizing campaigns. Unions would come in, get a hold of the employee handbook or policy manual, for example, and then go to the National Labor Relations Board, or have employees go to the National Labor Relations Board filing unfair labor practice charges, claiming that these social media policies violated their Section 7 rights. And in many cases, the board was willing to find that because all of these policies had been written both before the new decisions started coming out and really before too many people really understood what social media was all about in the first place. So that did have an impact on union organizing campaigns, and if nothing else, it created a hassle for employers who were probably happy to change their policy just to shut the NLRB up in some situations, but still had to go through the process up to the point where the union would either withdraw their charge or agree to some settlement. And many times, of course, the union was using that as leverage in trying to persuade employees to have them come in as the representative. As this happened more and more frequently, and labor lawyers like myself paid more and more attention to it, gave presentations, like earlier versions of this one, and wrote about it, companies started to face the question of whether they needed to essentially water down their policies, either because the NLRB came in and told them they had to in a specific situation, or because they just didn't want to run the risk of somebody saying that their policy was illegal. And based on the nature of the rulings, there wasn't but so much left you could do. It got to the point where often employers included right in their policies a flat out disclaimer saying nothing in this policy is intended to violate your Section 7 rights. Seemed like a good idea at the time to have that disclaimer, but even that down the road became problematic because the National Labor Relations Board would occasionally read that language and say, well, you can't expect employees to know what their Section 7 rights are, so saying that this doesn't violate your Section 7 rights isn't necessarily enough to make the policy lawful. Anyway, let's not spend too much more time on that. I'm going to go into the good news, at least again from the standpoint of employers trying to regulate their workplace in a reasonable manner. In December of 2017, the National Labor Relations Board, for the first time in a decade, regained a Republican majority. So the board was full, and the three latest appointees by President Trump were all Republicans. And not surprisingly, they immediately started trying to move the board policies back in the other direction from where the predecessor Democratic majority board had gone. There was a case involving Boeing where the new majority, over vigorous dissents from the remaining Democratic board members, essentially rewrote the slate, came up with a new analysis of how Section 7 would be applied to employer policies. Essentially, I think it's reasonably fair to say that the decision eliminated what had pretty much become a presumption that all policies were unlawful and restricting Section 7 rights. Not to say you couldn't have any policies during the previous years, but if it was anywhere close or arguably touched on Section 7 rights, you were probably going to have to make a strong case to explain why it was an acceptable policy, and still you're probably going to lose. So now, importantly, rules called facially neutral rules are now much more likely to be read as permissible by the National Labor Relations Board as reasonable directions and regulations on employee activities. Facially neutral rules are ones that clearly are not intended to attack Section 7 rights, but ones that the previous National Labor Relations Board were willing to scrutinize to essentially find a reason why they could say it violated Section 7. Since the 2017 Boeing decision, there's been subsequent guidance and rulings from the National Labor Relations Board, its General Counsel's Office, its Division of Advice, which all generally confirm the shift away from basically a labor-friendly view to one that is, if you want to call it more employer-friendly, or if you want to call it more balanced. I suppose that depends on your perspective. But it, as Boeing specifically did, lumps rules now into three categories. The first category are generally lawful rules. There's a large group of rules that are now generally okay and won't be scrutinized too, stringently. These include civility rules, no photography or recording rules, prohibitions on insubordination, non-cooperation, conduct negatively affecting operations, disruptive behavior rules, protections of confidential, proprietary, and customer information, prohibitions on defamation or misrepresentation, limits on the use of employer logos and intellectual property, restrictions on who speaks on behalf of the company, and bans on things like disloyalty, nepotism, and self-enrichment. Now, you may be sitting here thinking, well, these all seem like reasonable rules that companies will have, but each of these categories is the type of thing that the previous National Labor Relations Board majority found problematic under Section 7 of the National Labor Relations Act. So I will give you some examples. We'll come up with some more on some slides, but a couple of civility rules that have now been deemed acceptable that probably would have been found unlawful just a couple years ago include a rule saying that behavior that is rude, condescending, or otherwise socially unacceptable is prohibited. The previous board majority would have found that likely to violate Section 7 because employees have the right to be rude, condescending, or otherwise socially unacceptable when engaging in collective activity for their mutual aid and protection under Section 7. The National Labor Relations Board is now saying, okay, well, there's not enough in this rule that is going to convince employees that they can't exercise their federally protected right to try to improve their working conditions. Another such rule, employees may not make negative or disparaging comments about the professional capabilities of an employee or physician to employees, physicians, patients, or visitors. So obviously this is a medical setting, but the idea of negative or disparaging comments about the professional capabilities of an employee, again, is something that would have at least been carefully scrutinized under the prior board majority. To go in a different situation, there has been a more recent view that the following rule is okay: being uncooperative with supervisors or otherwise engaging in conduct that does not support the employer's goals and objectives is prohibited. Again, it seems fairly reasonable to require your employees to be cooperative with supervisors and prohibiting them from engaging in other conduct that doesn't support the employer's goals and objectives. But there was a time recently where the NLRB would say employees might read that to say you can't engage in union organizing, for example, because that doesn't support the employer's goals and objectives. The current National Labor Relations Board view is that employees either are or should be more reasonable than that to recognize that the company is talking more about their duties as an employee than they are talking about whether you can or can't talk to your coworker about whether you should be paid more, or even trying to get a union to come represent you. The second category is rules warranting individualized scrutiny. Now, as I said before, the previous majority of the board would have probably considered all of that past category to warrant individualized scrutiny. So this is really a shifting down the ladder somewhat of that analysis. Where there are rules that the current board views as warranting individualized scrutiny, the legality of the rule will depend a lot on context. This is what the National Labor Relations Board kept saying before. It was just pretty hard to provide the context that they thought was appropriate to make the rule acceptable. The board has said that this individualized scrutiny requires the rules be viewed as they would be by employees who interpret work rules as they apply to the everydayness of their job. And this is what I was just alluding to, kind of a reasonableness analysis that, look, I mean, we're not going to strain ourselves to come up with an interpretation that will necessarily violate Section 7. We're going to say, I mean, what is it most likely that the employer and employee understand this rule to mean in the context of doing their job on a day-to-day basis. But if you are thinking about whether a rule is acceptable or not, some of the factors that would play into that include the placement of the rule among others. In other words, if you have something that says you can't make rude comments in the context of something related to union business, then it's much more likely that it's going to be found unlawful. But as a general matter, it probably won't be. Examples provided in the rule, again, obviously, if your example is you can't, talk to union officials on your own time, then you're going to have a lot of problems. But if it's just, during your workday, you have to focus on getting your job done, such as responding to customer calls and filing the necessary report and locking your office after you leave, then the examples provided are going to help ensure that the rule is acceptable. And then they also note that the type and character of the workplace can make a difference. And then another potentially critical factor is whether the rule has caused employees to refrain from Section 7 activity. So if for some reason there is evidence that employees have actually read the rule to prohibit them from doing something that would be legal under Section 7 of the National Labor Relations Act, then the board might consider that in deciding whether the rule applies in an unlawful manner. Finally, the third remaining category are unlawful rules. These are rules that are pretty much unlawful per se or on their face, and context may not matter. These really fall into two categories, and they're pretty limited. One is restrictions on discussing wages, benefits, or working conditions. For decades, employers have not been allowed to tell their employees that they can't talk to each other about their salaries, or that you can't have a meeting to discuss working conditions. I mean, if you did something like that, even 10, 20, 30 years ago, you were in violation of the National Labor Relations Act. That's not to say that there aren't employers who still have those types of rules, and many states have additional laws that prohibit rules that would prevent employees from discussing their wages. For example, New York now has a law that says you can't stop employees from discussing how much money they make, among other things. Then the other type of clearly unlawful rule would be a prohibition on joining outside organizations or voting on matters concerning the employer. I mean, the gist of these rules is, I mean, you can't tell employees they can't form a union or they can't talk to union officials or whatever. I mean, you might be able to tell them they can't hold a union organizing meeting when they're supposed to be working, but you know, as a general matter, if you try to prohibit them from doing something that would enable them to potentially unionize, then obviously that's going to be problematic under Section 7 of the National Labor Relations Act. All right, I just want to break this up for a second and throw out a quick poll. I wanted to see how many of you have companies do you think have written policies covering the various issues that we've discussed? So you can just click one of the responses there. I mean, it looks like this is consistent, but what I expect is the majority of companies these days do have some written rules or policies that cover some of these issues in some direct or indirect fashion. So, of course, the take home there is, did you ever change the rules before when there was, the greater scrutiny? And if so, is it worth now revising the rules? Or if you never bother to consider any of these issues, do you want to do that now, or do you need to? If you've never done anything to be concerned with the National Labor Relations Board, other than if you have a rule that says you can't discuss your salaries, you may not need to do much based on this new guidance and trend. But if you certainly were in the category where you either wrote policies, had employment lawyers, labor lawyers review them sometime before 2017, where these restrictions from the previous board majority would have been in place, it's possible that you could now expand your restrictions in ways that wouldn't have been appropriate at that point in time. Whether you want to do that or not depends on various factors. What's good for your workplace, it being one of them, of course, but another is how long before the NLRB changes its mind again. So I always have to throw that out, because it's pretty likely that at some point a Democrat will again be president of the United States. They will then appoint a majority of Democrats to the National Labor Relations Board, and they will go back towards more restrictive interpretations of Section 7. Obviously, I say all this in an election year. You might have your own predictions for what's going to happen, but if hypothetically a Democrat is elected president, then at some point going forward, they may appoint board members who could go back to the Obama era interpretations of the National Labor Relations Act on any and all of the subjects we're talking about today. I told you there's 3 people on the board right now, all Republican appointees. That means there's 2 vacant seats. Another of the current seats will go vacant in the summer, September of 2020. So before the next election, we could be down to 2 members of the National Labor Relations Board. I think that's fairly realistic. I think it's unlikely that the 2 currently vacant seats are going to get filled anytime soon. The Republicans might appoint a 3rd member, because once they go down to 2 members, the board will essentially not be able to operate. At least it won't be able to decide cases. That has happened in the past and is certainly a realistic possibility later this year. All right, now I want to turn specifically to social media policies because, again, this was really what seemed to ignite the whole scrutiny of employment policies overall, not just social media policies. But again, there is now pretty good guidance telling us what is more acceptable than it might have been a couple of years ago. So in August of last year, the National Labor Relations Board released an internal advice memo that had actually been written the year before in 2018. They had to wait for the actual case against CVS, the drugstore chain, to get resolved. But once they did, they released their internal memo, which showed their analysis of various components of CVS's social media rules that were just like a lot of the other issues we were discussing. But again, for some reason, the National Labor Relations Board has become sort of famous for its scrutiny of social media policies over the last decade. Most of the rules were deemed lawful, which is certainly a change of what would have happened before. But a few were still problematic. So, okay, 1 second. All right, I know a couple people said the audio was bad. Is it back now? Can anyone hear me? Can anyone hear me? Okay, so we should be okay. If you're having trouble, then try to reconnect. Not much else I can do at this point. So I apologize for that little glitch there. Okay, so again, these are all actual policies from the CVS rules that the National Labor Relations Board internally ruled were lawful. They were acceptable, even though many of them probably would not have been a couple years earlier under the previous administration. So this includes employees who speak on social media about the company in any way must make it clear they are a company employee but are not speaking on behalf of the company. Use of any company or brand name or logo as part of a social media account requires prior company approval. Again, now that's okay. Before it would not have been. The previous administration looked at that and said employees have the right to use company logos and brand names in their campaigns for unionization or better working conditions. You could put the logo on picket signs, for example. So you could do it on social media, and restrictions on that violated Section 7. Now the National Labor Relations Board says, yes, they still have that right, but this rule is not enough to suggest to somebody that they can't do that. Employees may not post anything discriminatory, harassing, bullying, threatening, defamatory, or unlawful. Believe it or not, that rule would have been problematic before. Now it's okay. Taking or sharing photos from non-public areas or internal meetings is prohibited. Again, there's a change there. That would have been problematic under the previous board majority. Similarly, employees may not post content, images, or photos that they don't have the right to use. Companies overall, the board now recognizes, have the right to maintain confidentiality and other related concerns in the workplace. They also recognize that overall it's probably not a good idea to have people posting pictures of their coworkers. But again, there are ways you could write these rules that might make them illegal, but these types of general rules are now okay. Internal communications and information must be kept confidential. Here's one that was a big issue and litigated for years. Employees must use a disclaimer if they speak about the company on social media. So the NLRB now says that's okay. You can have that requirement. You can require employees to use disclaimers if speaking about the company on social media. Employees cannot give professional recommendations or references regarding current or former company employees through social media posts. This is, again, arguably limiting what employees say about one another, but the idea here is the company has the right to limit recommendations or references, but this rule probably wouldn't be interpreted to mean that one employee can't tell another future employer, yeah, Joe got fired from this company, but he got a raw deal or something along those lines. The NLRB is just saying, theoretically, if you fire Joe for doing that, maybe it would be problematic, but this rule on its face, just maintaining it in your handbook, for example, is not going to be enough to violate the National Labor Relations Act. So here are really the two rules that the NLRB did strike from the CVS policies. And they kind of cover two different issues. One, our code of conduct makes clear the importance of protecting the privacy and security of protected health information, PHI, personally identifiable information, PII, and employee information. Remember, CVS has pharmacies, hence the personal health information, etc. It is not permissible to disclose this information through social media or online communications. Why is this rule still illegal? It's because of the reference to employee information. Take that out, and I think there's nothing wrong with the rule, and even probably the previous National Labor Relations Board majority would have had a hard time finding a problem with it. Certainly, you can prohibit pharmacy employees from releasing PHI and personally identifiable information about customers. You just can't have a general ban on employees providing employee information, which might, for example, include contact information for your coworkers that you would want to share with the union organizer, for example. The other thing that's interesting when we're talking about social media policies is, how far does social media expand? Are we just talking about public posts on social media, or are we talking about direct messages through Facebook or Twitter or something like that, where it's a little less likely that it's going to be problematic for anyone if you're doing that, just like if you're talking on the telephone or sending a text message. So there's got to be some consideration to the breadth of social media, but again, under the current board majority, it's not going to matter as much because you have a lot more leeway to restrict things. Anyway, as long as you don't hit that employee information restriction, you're going to have a lot of leeway. The other one thing they found problematic is this other policy related to sharing personal opinions on social media about the company, etc., and saying when you discuss your work or the company in social media, you have to identify yourself by your real name and, where relevant, your title or role. You must also identify that you work for CVS Health and make clear that you're not speaking for or on behalf of CVS Health. The only thing that the NLRB seemed to have a problem with here was the requirement that the person identify themselves by their real name. Someone has the right to anonymously advocate on behalf of their working conditions improving or getting more salary, but that next sentence does not seem to be problematic to the current board, or at least the general counsel's office, which is responsible for bringing cases to the board's attention in the first place. So you could require employees probably to identify that they work for your company, and they have to make clear that they're not speaking on behalf of the company. You just can't require them to specifically identify themselves by their real name. Okay, so we really have, I think, 3 or 4 more topics that I'm going to get through relatively quickly. They're just kind of big picture highlights. We don't need to go into the details as much on most of them. But what I wanted to ask real quick before we wrap up, so I know where to focus a little bit of my remaining time, is whether your company has unionized employees currently. And in answering, you'll see where you can indicate whether, if not, it is an imminent possibility of unionizing. So we're seeing less than half say yes, we have unionized employees. A slight majority are saying no, we're not really expecting it. Again, all of the previous comments are still relevant. And some more of what we're going to talk about is still relevant even in that case. And for a few of you, there may be some possibility of unionization. Of course, you never know. If you're in the private sector and you have non-supervisory employees, it's possible at any time they could decide to try to bring in a union. All right, so I just wanted to know that as we wrap up. The next couple of topics are just decisions that came out in December of 2019, really right before the last Democrat on the board had her term expire. They wanted to get these decisions out likely so that she had a chance to write a dissent. But, still 3-1 in these cases. The company email use issue came up about 5 years ago in a case involving a company colorfully named Purple Communications, which always seemed to make it fun to talk about it. So the decision in 2014 said that under Section 7 of the National Labor Relations Act, all non-supervisory employees, at least, of non-government companies pretty much throughout the United States. There are some private businesses that aren't covered by the National Labor Relations Act or subject to the NLRB's jurisdiction, but they're either really small or in unique situations. But those companies had to allow employees to use even company-provided emails for protected purposes. In other words, the things that Section 7 allows employees to do, communicate about their salaries and working conditions or efforts to unionize. So at that point, there were lots of companies that said you can't use email for personal purposes. That decision said you cannot have that blanket prohibition. At the very least, they have to be allowed to use those emails outside of work time to engage in Section 7 protected activities. You could apply uniform and consistently enforced parameters. I mean, you could say you can't forward, attachments with viruses. And again, you could make people actually work on their work time and not try to send messages to form a union, but you couldn't pick and choose and say, yes, you can email your son or daughter's sports team about the upcoming practice, but you can't do the same for union activity. And again, even if you told them you can't send those types of emails about your son or daughter's sports practice, you would still have to let them, at least outside of work hours, use it for Section 7 protected activity. Well, the 2019, the Republican majority comes back into play and now has the case in front of them. Again, they have to wait for the case because they normally don't act by rulemaking to set substantive precedent. And they say, no, even if maybe arguably not really that was the case 5 years ago, now it's not. There's so many different ways for employees to communicate with each other that they certainly don't have a right to use their company email account, which ultimately is owned by the company, to engage in non-work purposes. They did allow that maybe there's an extreme scenario where the company email would be the only way that employees could communicate with each other. When they mention that, I kind of envision, some remote place where there's no access other than the internal company email system in Alaska or something like that, where you can't get a wireless signal. I mean, I don't think they'll ever find that, at least as long as this board is in control, which again, don't really technically only last until September as it is. But they did allow that possibility. Now, there's probably still the case that there are ways you could limit email use that would be problematic. Again, if you had a specific policy that said you can use your company email account for anything you want to, except exchanging information about union organizing, then you probably have a problem. But short of something like that, or applying your policies in that way, you should now be okay to limit your company email accounts. Question is, did you change your policy before to allow for what Purple Communications said you had to allow for? Did you change your practices in that regard? Or was it just something that nobody ever paid any attention to, in which case you probably don't need to pay much more special attention to it now, as long as you don't happen to have a policy that specifically says you can't use your email for union organizing activities or to complain about your salary. The other big decision that came out that affects potentially a lot of companies is regarding confidentiality for workplace investigations. In 2015, the NLRB surprisingly came out with this decision that said, no, you can't just generally expect employees to not talk about their involvement in ongoing workplace investigations, because they might have the right under Section 7 to discuss certain things with coworkers. But maybe if you make a specific finding of one of these four things, then in that case, you could ask people to keep it confidential. Companies had to show either that witnesses needed protection, there was evidence in danger of destruction, testimony was in danger of fabrication, or somehow there was otherwise a need to prevent a cover-up. So I guess if you had evidence that employees were trying to meet after hours to get their stories straight, you could try to shut them up from doing that. But it wasn't just that any of these things are possible in any investigation. You would have had to have convinced the board you had actual evidence of it. A December case called Unique Thrift Store, involving something called that, gave the board an opportunity to reverse that decision, restoring the default concept of maintaining confidentiality to the extent possible, which is what the EEOC, another federal agency, has always maintained was what you should be doing in internal discrimination and harassment investigations, for example. There had been a clear conflict between these two agencies. They'd actually been meeting to work through. So I guess this is how they've now worked through it. The NLRB says, look, you can maintain confidentiality without violating Section 7. And in their decision, the board emphasized the importance of confidentiality to both employers and to employees during ongoing investigations. In other words, the investigation is going to be more effective, and we're going to get the truth, which is going to benefit everybody involved. It's not that we're just protecting employers, but it's better for the employees too if the investigation maintains sufficient confidentiality to avoid things like evidence being destroyed, fabricated, or cover-up being organized. So again, probably a lot of companies never noticed Banner Estrella Medical Center. Many others did pay attention to it and changed what they told people during investigations. Some people, probably actually got taken to task for asking employees to keep things confidential. But regardless, you have much more leeway now under the new Unique Thrift Store decision. This slide didn't come through right. It's supposed to be a blue ballot box. But the last thing, no, not the last thing. The next thing I need to cover, and we're not going to belabor this because hardly any of you are going to have an election soon, In 2014, the NLRB changed their election rules, which were kind of known as the quickie election rules, basically because it sped up elections for whether a union was going to come in or not from about 38 days on average to 23 days on average. The procedures were clearly designed to get those elections taking place very quickly, basically on the theory that the more time after the union files an election petition that the employer has to respond to it, the better chance the employer has of convincing employees that they don't need a union. I'm going to editorialize and say what I think pretty much everybody else would agree is the truth is that the Democrat comprising the majority in 2014 wanted more unions to get elected, so anything they could do to make it easier, that's what they were about. The new rules will take effect April 16th, 2020. They were just finalized, again, by the new Republican board majority. The last rules required employers to submit this written position statement in 7 days after learning of the petition for an election. Now they have 8 business days, so that works out to be, a few extra days. The union also now must respond with a position statement, which they did not have to do before. There's a pre-election hearing that happens if parties don't agree on all the details of the election, including who can vote and who would be represented by the union. That used to happen 8 calendar days after the election petition was filed. Now it will be at least 14 business days, and actual issues can be decided at the hearing. And there can actually be witnesses and post-hearing briefs, which the 2014 rules had eliminated. So before there was going to be a hearing, but basically all it was there to determine was, well, is there already a union? No. Okay, then we're going to let them vote to determine whether there is a union. And most of the other issues that might be in question, like, is this person a supervisor or not, which determines whether they should or shouldn't be able to vote and whether they can or can't be in the union bargaining unit, would be left for after voting. So that person would vote basically with a challenge to their vote, and if the vote mattered based on the count, then the dispute would be decided after the fact. Again, the idea being we're not going to decide anything we don't have to, because that slows up the election process. So now the elections will be scheduled normally not before the 20th business day after the direction of election. Direction of election occurs either after the hearing or once the parties agree to all the terms of election, if they don't need to go to a hearing. In effect, this is going to return closer to that 38-day versus the 23-day timeline. So it's going to add a couple weeks at least to the process, which generally, again, is considered to be good for employers because it gives them more opportunity to respond to the union organizing effort and get their message out to employees. Voter lists, I add that in here just kind of for general information. So once an election happens, or once there's going to be an election, the company does have to give names of contact of employees with contact information to the union. We still have to do that, but there will be more time to prepare the list once the election is going to happen. All right, then just two more slides, I think, to go over real quick. We're just about at our hour here. There was a decision in December of 2019 involving Walmart where the NLRB allowed or upheld a company policy that employees could only wear small, non-distracting union buttons in customer-facing areas. In other words, for Walmart, on the store floor, the issue of union buttons has been litigated before the NLRB for years and years. The idea being employees have some right to let their union status be known. Under the previous board, restrictions on that obviously were relaxed, and here we are returning to a more restrictive view where the policy is okay saying small, non-distracting. Obviously, the picture I have here, they have some relatively small buttons. I think if you had an employee wearing that many of them, though, most people would find that distracting. There's different rules that apply for patient areas, what nurses can wear in hospitals and things like that. But this is a rule that, is of some interest and relevance and recently came out. Another important recent change in rules from December, there was this issue of union dues that when the collective bargaining agreement between a company and their union expired, normally in the past, employers could then stop deducting union dues from their employees' wages, or normally the contract required that. When the contract expired, you didn't have to do it anymore, which obviously was some inconvenience to a union, because if they wanted their union dues, they then have to find a way to get it from the employees themselves. In 2015, the previous board majority said, no, you can't stop giving that money for various complicated legal reasons. We think that you still have to send them the money. But now the board has gone back to the precedent established in 1962 that lasted for over 50 years, saying, yes, employers, if you want to, you can stop deducting the union dues while no contract is in effect. Sorry, I thought there were 2 slides. One more. There's also a recent change in the deferral to arbitration decisions. This is a situation where in the union context, you might have an arbitration procedure for grievances under your contract. Unions can also file unfair labor practice charges with the NLRB. Sometimes they would do both. In 2014, the NLRB made it very difficult for a company to try to enforce and rely on an arbitration decision if there was also a related unfair labor practice charge. Essentially gave the NLRB the right to second guess an arbitrator in application of NLRB jurisprudence. The case involving UPS in December restored the previous less stringent standard. The NLRB will defer as long as the factual basis in the arbitration was parallel, is the word they use, to the facts relevant to the unfair labor practice, as long as, or even if the arbitrator didn't expressly rule on the unfair labor practice under applicable NLRB standards, which would have been required under the 2014 Babcock and Wilcox decision from the NLRB. One last thing that's interesting about this case is it was decided after Member McFerrin's term expired, meaning there were only 3 board members and all 3 of them were Republicans. This is somewhat noteworthy because historically the NLRB has refrained from reversing precedent on major issues without at least one member of the other party there to write a dissent of the decision. This board here is showing that they may indeed be willing to use their 3 remaining Republican member advantage to issue decisions. And again, I don't think we're going to get another Democrat appointed to one of the open seats before the next presidential election, although I suppose that's just a guess. So that could be telling that the board is going to keep doing business as usual, despite what historically would have been a limitation that they impose on themselves. Certainly nothing illegal in proceeding this way. Again, just not what has typically happened. All right, so if you have any questions, make sure you're entering them now. In a moment, I'm gonna give you the link to the slides. Thanks for going a couple minutes over the hour. I will answer any questions you have. Just anyone who wants to make sure you get our announcements of future webinars and is not on our email newsletter list, you can sign up on the website or otherwise contact me, and I'll put up my contact information in a second. We also encourage you to follow us on LinkedIn if you're at all active there, because we're able to more frequently put out our updates through there, so we don't want to bog down your inbox on your email. That's a monthly newsletter generally. And then here is the link to the slides. You will also get an email tomorrow that has a link to the slides, and you will also have access to watch this video again, a video of this replay, a replay video of this webinar again, or share that with colleagues if they also would benefit from this information. I'm going to take the questions now. And here is my contact information if you need it. So at the moment, I don't see any questions. So if you had a question, thought you had typed it, I don't have it, so ask it again. Sorry for rushing through that last part. I will just say that kind of the take home that I think you can see from this presentation, again, is A, that all of these changes are in the direction of most likely making life easier for employers. There is one caveat on the change in the election rules. Again, they don't take place until April. In the meantime, we're in the more expedited election regime of the previous rules. So that does mean that it's possible that unions will file more quickly than they otherwise would. So if you are possibly facing a union organizing campaign, the union might have some incentive to try to file an election petition in the next 3 months or less than 3 months before the new rules take effect. I mean, I don't think any reasonable union is going to file the day after the new rules take effect if they could have at all possibly done it before that under the old rules. So that's one consideration. Again, as I mentioned before, we are in a wait and see situation while all these new rulings are shifting back in a certain direction. Within a couple of years, there could be a further shift, a reversal back. I mean, love it or hate it, the NLRB is now in this cycle of alternating viewpoints depending, largely on who controls the White House. It's not unique among government agencies, but because they operate mostly under this sort of case-by-case adjudication issue and at the same time aren't afraid to change their precedents, it does make it hard for employers to predict what the standards are going to be, unions to predict as well for that matter. So still don't have any questions popping up, but the other thing is you probably at least want to look back over your policies and procedures if either they were revised in light of previous NLRB decisions or you're not sure if they were, then it would be a good opportunity to reconsider that and whether there is something that you would like to treat differently while you can. So I'll wait about 1 more minute. If I don't have any questions come in, then I'll let you all go. If you have a question forming, type something so I know that. Hopefully the information was valuable, and hopefully the lack of questions means you understood all of the issues, and we likely will have another webinar coming up in February, although I don't have a topic set. So if you have something top of mind, feel free to reach out and let me know what your thoughts and preferences would be. Likewise, if there's a better time for you for these, let me know. Otherwise, I appreciate everyone attending. Like I said, it was a very good turnout, and hopefully we will continue to see you at future webinars. All right, thanks everyone. Take care.